Welcome, everyone. Today is September 3rd, 2020, and it's Mediation, the New Possibilities Hour. Our special guest today is Monisha Coelho. Monisha is a partner in the California law firm of Alvarado Smith, with 3 offices throughout the state of California. Monisha specializes in business and real estate litigation, and also she's licensed to practice law in India, and as well as in California, and continues to represent a number of clients from India in their business dealings in California and around the world. This program, the New Possibilities Hour, is of course part of the Will Work for Food project. We don't charge for these valuable webinars. Rather, we ask you to contribute to a food bank of your choice if you like what you see. And Natalie, I believe we have some big news to share with people today.
We do. Our industry should be really, really proud of itself, Jeff. We finally surpassed the $50,000 mark in donations to food banks worldwide. I'm so grateful to our industry.
That is awesome. And it's because of the tremendous generosity and kindness of people on this call, this webinar, and the people who've been on these webinars over the months that we have been producing them. So thank you very much to everyone. Monisha, I understand that you have a particular food bank in mind that you would like to mention. Would you like to tell us where you would like people to direct their contributions if they're able to do so?
Yes, thanks, Jeff. I think my food bank of choice is the St. Joseph Center in Venice. And they have a very large and robust program in terms of the food bank and just a host of services helping low-income and needy families. And I have volunteered there through my religious organization a few times. And I really respect the work they do.
That's beautiful. Thank you. And Natalie, I believe you've posted the contact information for St. Joseph's in the chat box. Is that correct?
I did. The St. Joseph Center website is St. Joseph, STJOSEPH, Center, CTR.org, stjosephcenter.org.
Beautiful. And it's Venice, California for our international audience. Venice, California. That's great, Monisha. So Monisha, I just want to point out to our audience that you also hold an exalted place in the world of litigation in that you are the immediate past chair of the litigation section of the Los Angeles County Bar Association, which is a section which is bigger than many bar associations entirely, with over 1,000 members. And through your leadership of that section, you've gained a tremendous big picture perspective on the world of litigation. And you were the chair when the pandemic struck, and so you really got to see a lot in terms of the way changes were happening in the world of litigation, relationships with the court system, and beyond. You have so much to share with us that's so valuable. Please, the floor is yours.
All righty. So good morning, everyone, and welcome to this program. Jeff, thank you so much for having me. I am really honored, and I'm excited to be here. So my name is Monisha Coelho. I'm a partner at the law firm of Alvarado Smith in downtown Los Angeles. I am a business and real estate litigator. I also handle a cross-border India-US practice. I grew up in India and I practiced law there before moving to the US. I am duly licensed and I represent clients in cross-border India-US litigation, corporate matters and transactions, and in real estate and property matters. My firm, Alvarado Smith, we are a full-service law firm. We have 3 offices in downtown Los Angeles, Orange County, and San Francisco. We handle a range of litigation and transaction matters, whether it's property or corporate. And I think that's all the introduction I have. I will say my law firm, Alvarado Smith, we are a minority-owned firm, and we are truly diverse in that sense. Before I, actually start talking, I will do the usual disclaimers. The information I provide is not legal advice. If you want legal advice, feel free to reach out to me via phone or email. My information is on the firm website. You can also connect with me on LinkedIn. The views I share here today are my own views. They are not of the firm or of anyone else. I will move on. Alrighty. So one of the things, let me back up. So Jeff asked me to talk about litigation in the new normal, during this time in 2020 and beyond, and suggested a few particular topics. And so I will try and run through those 3 or 4 topics with a couple of remarks on each topic. So you won't have me talking endlessly. And then I guess we will do questions. So I think the first question Jeff suggested I talk about is how litigation has changed. One of the running jokes in the legal community about the difference between litigators and non-litigators is that litigators actually know what the inside of a courtroom looks like. And in the new normal, that one thing, which is the foundation of our practice as litigators, being inside the courtroom, has gone. So it is no longer possible for us to meander the hallways of the local courthouse, which, you could go from one courtroom to the next, wait for a mediation in court. And now all of that has gone. So all that stuff has moved online. And I think that is one of kind of the biggest changes. I think the other big piece is oral arguments. So where we as litigators really stage our court craft is in our oral arguments before the judge. We walk in there in person, usually with a big binder, all our cases tabbed, all the pleadings tabbed, a notepad with, all the key sites and the page numbers on hand. So you could look at it in a second and point the judge to the correct page to read, an excerpt from the brief, or point the judge to the exact piece in the case law where your oral argument rested. So that piece of oral argument is now also has moved online, and we can no longer do that piece. As an immigrant to the US, a lot of times when I was at Stanley Mosque, the courthouse in downtown Los Angeles, you park your car. First of all, I think that the other thing has changed. I would leave an hour and a half ahead of time to do an 8-mile drive from West LA to downtown Los Angeles to the courthouse. And I was always sweating the night before with 2 alarms set, barely, trying to make sure I woke up on time. Nothing untoward happened. I was on the freeway ahead of time, pray that no bad accident was going to happen, try and get to the courthouse at least 30 minutes ahead of time. So you had time to park, go through security, and you were sitting outside the door of your courtroom at least 10 or 15 minutes before the doors opened. I think 10 was cutting it too fine. 15 was safer. And then, you walked into the courtroom and you were there. And a lot of times in downtown LA, you park on one side of the street and then you cross over. And as you're waiting at the traffic light, there's a whole host of other suits and lawyers like you, with their big briefcases waiting to cross, across the street to walk into the courthouse. And a lot of times I would stand there and think to myself, in the bright sunlight at kind of 8 o'clock in the morning, I would always think, wow, am I really doing this? Growing up in India, I never thought I would one day be practicing law and arguing cases in a courthouse in downtown Los Angeles. And so it was I had to pinch myself a few times when that happened. And again, we don't have that ability to go in, to stand before the judge, in some way read the judge's body language and facial expressions about whether a particular argument I was making before the judge was resonating with the judge was listening or not listening, the judge was not so keen on that argument, or the judge didn't really believe that, that the argument was in good stead for my client under those particular facts. It could have been in good stead in another matter, but in these facts, the judge was not quite buying it. And you could read those, that body language, the expression of the judge. And sometimes if I noticed that the judge was not all there present with me, and not because the judge was not present, but because they were kind of thinking, yeah, I'm not buying this argument your client is making, I'm not seeing it the way you're seeing it, it was possible to stop and redirect and say, Your Honor, is there a specific question Your Honor would like me to address? Or, and it was possible to do that in real time. A lot of times opposing counsel would jump in the middle of your argument, and then you could address that right away. Or sometimes if opposing counsel was referring to pages or an argument that they were making before the judge was not completely accurate, I could jump in and say, Your Honor, that is not borne out by document on page 20 of the brief, or, by this one. And sometimes the judge would stop and say, what page are we looking at? And then you would flip through the pages and go through that. And it happened quickly. I don't think that has changed, because now we are all online, and the dynamics of the oral argument has changed. So I think and I think the third thing I will say is drafting briefs and filing them, all that has changed as well. Today, I sit in West Los Angeles. My support assistant, the person at the firm who does all the court filings, sits in another part of the city. My office is downtown LA. And so there's people in different parts of the city we are all working from home, because my law firm has encouraged everyone to work from home, trying to get a filing done. As opposed to, I would walk out of my office and chat with the secretary or the assistant and say, here, let's get this filed. We could pop in and out of each other's office and ask for a clarification. And now it's either through the phone or via email. And so filing anything in court also has changed pretty significantly. In terms of how the life of a litigator has changed, I think one of the biggest things I would say is law, shocking as it may seem, is built a lot on camaraderie. You will not see it with opposing counsel, but you will see it a lot with your own team and the lawyers in your firm. Law is also a craft, for me, that comes with practice. It's not just the stuff out of the book, it's experience and expertise. And oftentimes, when I run into a tricky question or situation, lawyers will walk down the hall to the next office and say, hey, I have this particular situation. Have you experienced it before? Or what do you think about it? Or I'm going to make these arguments. What do you think about it? And that ability to quickly walk down the hall and pick someone's brain has gone. And that camaraderie has gone, Yes, I work from home, I work long hours, and, I get the job done. But that collegiality and those relationships, that has changed. Also, the hours we work has changed, because now it's a short, I don't drive, so I'm at my desk. I'm not driving to work, so I'm at my desk, and then, I have to enforce time limits and boundaries so I can stop the work day and then start my day. I learned a long time ago that just working endlessly, made me less productive. If I didn't have clear boundaries on the workday and the weekend, I was dragging the next week, and it would take me more time. And so I've realized the value of getting breaks in. So when I came back, I was refreshed, I was recharged, and I was not taking one and a half times to do the thing I would normally do in, say, X amount of time, just because I was tired and, just dragging. And so, it's been important for me to create my own boundaries, to make sure I get out in the evening and work, so that I can separate out, just being at home from actually getting outside, since I'm not driving to the office. I have been doing a lot of meetings on Zoom, either with clients or with opposing counsel, or just on various business development matters. And so, I spend a lot of time now on the computer talking with people like I am doing right now, as opposed to, in-person meetings in the office. I have gone into the office a few times to have in-person meetings with clients when we were not in lockdown. And those meetings have involved wearing a mask, having the client, my law firm has large conference rooms in all our offices. So it's easy to have the client sit 6 feet apart and make sure everything is disinfected before and after, and, maintain all the protocols. So I have had those in-person meetings. They have been helpful because we had to go through volumes of documents, and the client wanted the in-person interaction of being able to present their story and, what they think happened in the case. So I think that has been, that's a few times I've done it, as opposed to kind of more routine day-to-day meetings with clients that would have happened outside of COVID. So, it's kind of those protocols. I will say that the move to technology has been easy. I mean, the move to working from home has been easy for me because I am used to working with the technology. I'm fine working with a cloud-based, my firm is entirely on a cloud-based platform, so we can work remotely from any part of the world. Because of my cross-border practice, I go to India a couple times a year. I also have family in India. And so with technology the way it is, I have been able at 9 o'clock in the night in India, on the way back from a family dinner, or, on the way back from doing something else, to sit in the car. It's common to have chauffeurs in India, or if I'm taking a cab somewhere, and be on my tablet or my phone responding to emails in the US, or working on documents, because there's a 12.5-hour time difference. And when it's nighttime in India, it's the morning in the US. And so, for years now, I have had to leverage technology and really use it. And so that it didn't matter whether I was sitting in India or in LA, I could, look at my documents, respond to clients or to a question where it was needed, and be available, including doing phone conversations. I would just schedule them at different times and be able to do that. So the move to technology was not difficult for me, but I know, in talking with other attorneys in the profession, that it has not been easy for most people. And having everything online, it has been a challenge. Relating to clients, I think in some ways, the video piece is actually helpful, because earlier, if I talk to clients in India, or even kind of within the city, given how difficult it is to commute in Los Angeles, clients prefer doing telephonic conversations. And now with video, I think it's more personal to talk to a client. I think most clients that are in businesses are now totally used to doing video meetings via Zoom or any other platform. So in some ways, it's helped it make it a little more personal. The client doesn't have to spend a bunch of time, coming to the office. I can speak with them personally via the Zoom platform. So that has changed. I think the other thing that has changed significantly for clients is requiring us as attorneys to be a lot more cost effective and be far more strategic in the way we do things, because in this new economy, finances has made a significant difference. So costing is now top of mind for a lot of clients. you know, and it will be for the immediate future. And it requires us as attorneys to be far more strategic in how we're moving a case forward. I will always say that I have worked with a lot of founders of businesses, and I know for them the cost benefit analysis is critical, and I think that's something that I always looked at in the work I did so far. So for me, it's not, you know, that much of a shift. I have not worked on cases where money flowed freely. I shouldn't say that. I said, even in cases where money flowed freely, you know, I recognized that a gigantic litigation bill is not a great marketing strategy. It doesn't help the client. Draining the client's coffers through litigation never helps the client. It doesn't leave a good impression of the legal system with the client, and the client is unlikely to come back to me if that was a strategy, if I made money off the client. And so, and also just to recognize, right, what is of that importance to my client, right? If I'm on the same team with my client, handling my litigation in a way that fits within my client's budget is critical. And I cannot just run up a bill, knowing, you know, understanding my client's business and how big or small that business is and how they work. So I think that has always been part of the way I protect and defend my clients. And I always say, you know, for me, my job as a lawyer is to protect my clients and to make sure they don't leave money on the table. And, you know, and so running up a legal bill doesn't fit with that strategy. So I think the cost effectiveness is something that will, you know, really follow us in the years ahead. And then the last point I will talk about before we open in for questions is saying how settlement and mediation has changed. I think there's definitely an emphasis in resolving matters sooner than later. I will say that to some extent, you know, I have always, let me rephrase that. I have always tried to try and resolve matters directly with opposing counsel, because at the end of the day, right, I understand the numbers involved. At the end of the day, settlement and mediation, or settlement, a lot of it is about numbers. Excuse me. What's the other side asking for? What's my client asking for? What's the money on the table? What's the dollar value? What are the abilities of both parties to pay? And how will this thing work out on a numbers basis? And a lot of that comes from working up the case. If you've done your homework and you know every bit of piece of information on your case, you have a good sense of what the numbers are, what's the strengths and weaknesses of your client's case. You know, and I will say that I am incredibly hardworking. I am meticulous when it comes to details, and I will read every single shred of paper there is, pretty much line by line, because I know what's in my papers. And I will tell you the number of times that one sentence tucked away in a long document or, you know, in an email can make or break a case, because someone admitted to something or agreed to something or, you know, denied something that, you know, either gives you a cause of action or takes away your cause of action, puts you within the statute of limitation or takes you out of the statute of limitation. So it's the little minute details that are critical. And when I have gone through documents like that, if you get 7 or 8 little minute details, you have a pretty good little armory or, you know, of facts that now start tipping the balance of the case in favor of your client. Because you have these little details on their own may not be significant, but when you put them all together, you have concrete facts, numbers, and data that now start undermining or demolishing the other side's argument. And if you put those in a brief, it's a compelling argument for a judge. If you talk to opposing counsel and they're reasonable, you can run through your facts and go, here's what I got, right? I got client admitting this on that date. I got these invoices. I got, these bills that absolutely do not track with what your client is saying is owed because they belong to a completely different case or whatever that might be, right? And then, you start your discussion with the other side and say, okay, here's what my client's willing to pay. And, as we all know, the opening number tells you a lot about the strength or weaknesses of your case or the other side's case, where they're willing to start. And because eventually where you start, you end up, you haggle or you negotiate and you get somewhere in the middle. And so the starting point of where either party is critical in determining where you will end up at the end of the day. Because you have to give room for the other side to move forward, and you have to give room for your client to move forward as well, to increase the offer or reduce the offer, and the other side to increase or reduce the offer. So I have usually started with those kinds of negotiations with opposing counsel. And then, if it reaches a complete impasse, then, we take the case out to a mediator and have, a mediator resolve the matter. And so I think more clients today are interested in resolving a matter, but again, not at a throwaway price, right? They still want value for the amount of money that has been spent in litigation, for protection of their rights, to remedy whatever the injustice or the wrong has been. And so I think there is definitely a greater emphasis on mediation. The challenges of not having in-person mediation are definitely there in terms of not being able to read body language, not being able to communicate one-on-one, not being able to say, okay, we understand where your client is coming from. What I'd like to share with you is what my client's perspective is, the harm he has suffered. He's a mid-sized business. This is what happened. These are the other things that happened to him as a consequence of whatever this contract falling apart, the other financial consequences on him, or this is how it's damaged his business. And to be able to present a human argument to a human side, to the numbers, the causes of action, the legal claims, the legal defenses. And I think for me, a lot of times that honest, flat out, here's what my client is, right? It has been invaluable because you can't argue with the truth. You can, but at some level, everybody, every human being, every lawyer, every judge, every mediator, every client recognizes, whether they will like it or not, they recognize that the truth is the truth and the pure facts are the pure facts. They may not like it, they may not want to agree with it, but there's still 25% of their brain goes, yeah, they're right. That really had cascading negative financial impacts for the business, right? They may argue against it and, be angry, but they recognize that. So I think we've lost to some extent that. But, what I'll say in closing is this, that the technology has moved forward. It is here to stay. We all need to embrace it. I really give kudos to the court system and the LA Superior Court system and the other courthouses in Orange County and in Inland Empire and, other parts of the state that have moved so effectively and efficiently into using online platforms. I never thought I'd be doing video arguments before a judge, or, there was court call before and we did brief, telephonic hearings before the judge, but now we're doing more substantial arguments either via telephone or on video. And I never thought we would see that. And so similarly in mediation and arbitration, we're going to see a lot more video, and the more we embrace it and the more we find ways to make it work, I think the more successful we will be both in our practice and for our clients.
Tremendous. Thank you. As mediators, we really need insights into what's going on with the lawyers we serve, how they're thinking and feeling about things, and you've shared so much information with us. Let me ask a couple of questions to start off. You talked about having some meetings in person with clients with masks and social distancing and all that. Can you compare and contrast for us what it's like to have a meeting with to prepare for deposition or go over documents, what it's like to have that meeting in person with distancing and masks as contrasted to having that meeting on Zoom or one of the other platforms using screen share to show documents?
Yeah, it's a little more challenging, simply because for us as lawyers, or for me as a lawyer, I am completely fine with reading documents online. I mean, when I first started practicing, the Rudder Guide was my Bible, and I always joked, if it wasn't in the Rudder Guide, it didn't exist. So, you know, too bad for you. In my life in general, it was either on the bar exam and it existed in my reality, or not, and it was either in the Rudder Guide and it existed in my reality or not. And I always say, you know, humor was not on the bar exam, so most lawyers don't have a sense of humor. But you know, so even Westlaw now, from the days when we read it all on books, is all online, and I highlight and I have notes and tags and all that kind of stuff. But for a lot of clients, it's not the same, right? So while it may be completely fine, and I have gotten used to, because it did take some time getting used to moving from paper documents when we were reading everything and highlighting documents and making notes on pages, to doing the same thing online in PDFs and highlighting your PDFs and things like that. So it's easier for me, but it's not easier for the clients. And so it's a little more challenging for clients to focus on documents. You know, if they're not doing it on a day-to-day basis, and you know, to work, to be on the same page as me in terms of reading it, analyzing it, pulling out the salient pieces. So, I mean, the way I read documents or Westlaw, my cases online, is I always highlight the relevant stuff. And it may be more time consuming up front, but it saves me a significant amount of time later. And so I highlight stuff so I can screen share with a client and do it. But there's definitely something lost in you know, being able to really communicate with the client one-on-one and say, okay, this is the critical piece in this document. You know, here's an argument that we're making about this document, or, you know, about the language or the facts in this, or there's something that's stated in this document. How do you see that? What exactly happened here, right? So when I'm sitting one-on-one, the client can look at the document and then they're just talking to me, right? But when we have a screen involved in all this, it's a little more difficult for the client to get the full import of what we're discussing. And again, it's different. So for my clients that are large corporates and, you know, in-house counsel or whoever we're working with is doing this on a regular basis, it's easy. But for my clients that run businesses or own or run businesses, and my practice is, you know, I have a lot of clients in the technology field, in tech and in biotech, some extent in nursing homes and healthcare, and then some hospitality and, you know, hotel owners and things like that. So, you know, I may have a client who is running 10 nursing healthcare facilities, and they're not, he or she's not sitting on a computer all day. You know, they're busy running a business, so they're not that screen savvy with reading through documents in that sense. And so that is a little more difficult. You know, prepping a client, you know, running through the same way we prep a client for deposition. You know, wait for one question, for the question to be asked, think about it before you answer, you know, wait for objections which I may make before you answer, reviewing the document, take your time to review the document before you answer. A lot of those things are changing because I'm not sitting next to my client, right? The client doesn't have the comfort of their lawyer sitting next to them. The document's not in front of them. It's not something they can tangibly touch, you know, and so that is a little more challenging. Also with the other side, I don't usually give my document exhibits or in a deposition. Opposing counsel or I will not give the other side the documents ahead of time. right? So then that slows, so that means, because you always want the element of surprise, like here's an email, or in a certain order. You said something about that, but now I have a document that completely contradicts that. So how do you explain that? So then the screen sharing, the moving back and forth is time consuming. If it's my client, it's just a little more difficult for my client to do it. And, my client feels a little more trapped, which I don't want. I don't mind if it happens to the other side, but I don't want my client in that situation. So it's a little bit more of a pressure cooker for the client.
Fascinating. Let's talk a little about relationships with opposing counsel. Sometimes lawyers have reported that it's awkward or difficult to propose mediation to an opposing lawyer without it seeming like a sign of weakness. There are many other things about which lawyers need to meet and confer, discovery matters and other things. Is it easier to have a collaborative element of the relationship with opposing counsel nowadays with technology, or is it more estranged and distant?
I love the law. I love the law. I like reading case law. I think really well-written, reasoned arguments in case law is like reading poetry. So I am a bit of a law nerd, I am. What I do not like about the practice of law is the fighting with opposing counsel. And I practice law in India, which is very much based on the old British system. It's kind of very formal and dignified, and you wear your robe, and it's a very intellectual enterprise, and your arguments are very, refined. And when I moved to the US, it was like culture shock, because the most successful litigators followed a scorched earth policy, which meant you destroy the other side at any cost, and that's how you win. I remember very clearly people referring to a particular litigator at a particular big firm as like he follows the scorched earth policy. It was like awe and or admiration and or fear. And I think that's the piece of the profession that's the most emotionally exhausting and a waste of time, and just useless. And so, especially as a woman, and a woman of color, I don't have the luxury of getting into those spitting contests with opposing counsel, because I'm not going to scream and yell like the male lawyers do, which they do sometimes. There are very much different standards for the way a woman practices law versus a man practices law. If a man is very authoritative and raises his voice, or he's being strong, if a woman does the same thing, there's a very negative word that's used for her that starts with a B. And so there's very different standards for the way women practice law and the way men practice law, or allowed to do so even today. And then just, I will say there is a size difference. And I would be lying if I said that people did not use that. Let's just say people do. And so there's a physical difference between you and your opposing counsel. And people do use that to their advantage, or think they can. So in the face of being a smaller brown woman, I use what I have best, which is my intellect and my hard work. And so I will work my cases up down like exhaustively. I know every piece of paper, and strangely, I remember the stuff. And I know the details, and I know exactly who said what to whom, when, and why, and what happened when. And I can pull out that exact document for you and go, no. You may say this, but here's the documents that say otherwise. So for me, suggesting mediation or settlement is when I know my facts excruciatingly well. And then I recognize that either I have the upper hand, or my client has the upper hand, or it doesn't, based on the facts, right? And then if it's damage control to limit the exposure to the client, I still have some facts that support me, that say, my client is not completely wrong. Here's how the other side participated in this wrong. And here's why, settlement for both sides is good. And if I'm on the other side where I have all the facts, I will say, here's the facts. We can keep litigating this and spend a lot more money, or we can take that money, take that client's money that would otherwise be spent on legal fees and put it towards a settlement. And, and you pray that the other side is reasonable and they want, what's best for their client, and that they will agree to do that. So for me, that has always been the way I would approach a mediation or settlement. I don't think that really changes during this pandemic and in the years ahead. But what I will say is, I think there might be a greater emphasis now on willing to settle easier or mediate, earlier, not easier, to settle earlier or mediate earlier, and to be willing to concede more just because of the circumstances we are in the sense that it's in the client's best interest financially now to have a litigation resolved sooner than later. So, where financially for the client from a cost-benefit analysis, it makes more sense to look at mediation sooner than later because of the economy and the way, the financial situation is for most businesses, then I would start doing that, and I would approach opposing counsel earlier. And I think I would be less concerned about how it looks and more concerned in what's the best interest for my client. And I think if I come from that perspective and say, the dollars and cents count for all our clients, and this is what makes most financial money sense, I'm willing to look at this. Would you be open to trying to resolve this sooner than later so that we can do what's financially best for the client? Right, litigating it, and I always say this to my clients when they, they're like, we don't want to just take the other side to the mat, and we need to show them. And I said, I'm happy to do that, but you have to remember the only person who's going to make money, and that is me. The more you want me to litigate and fight with the other side, the more money I make and the less money you have. Is that what you want? And clients always say, oh, no, we don't want that. And I'm like, okay, good. Then we're going to do this in a reasonable way where we're going to look at the legal arguments and the facts and focus on those and less on the drama and the personalities, and find out the most cost-benefit way or the most financially savvy way of getting to a good result for everybody. So I think everybody has to bite the bullet and say, what's in the best interest of the client here? How can we resolve this and get what everybody wants sooner and faster? And you put your ego aside and say, this is business savvy, this is client savvy, this is the most prudent, practical way to handle matters in the new normal.
These insights are tremendous, Monisha. As in your role as chair of the litigation section, you were dealing with a lot with the Los Angeles Superior Court and the Federal Court for the Central District of California. And as mediators, it helps us to understand what's going on in the court systems and how they're adapting to the COVID-19 crisis. What insights can you share with us about things going on in the court systems that would help us help you?
Yeah, sure. So I think, I will say that the courts have done just an outstanding job in how fast and quickly they adopted technology. I think if you spoke to lawyers in March, in the first week of March or in February, and said, oh, you do oral argument via video, they'd be like, that's not possible, right? If you asked me, I would have said, not really, but it is now. And I know that at least for the LA Superior Court system, they were contemplating a more online platform to more effectively handle just the gigantic volume of cases that goes through the LA Superior Court system annually. And then they had to speed all that up to, instead of waiting 2 or 3 years to implement that technology, to do it in 2 or 3 months. And so the courts did. To me personally, it was mind-blowing. because most corporate sector businesses have not adapted that fast as the court system, and they're a government entity, right? They're bound by state regulations, county regulations, you know, a whole host of matters. And so it was challenging for the judges. You know, the courts were closed and matters could not be heard or filed or processed. So there's a huge backlog, and it would take a very long time for the judges to process through the backlog, because cases are filed every day by the hour and the minute in the LA Superior Court system. So you have that volume of cases coming in, plus a number of cases that were not attended to. So, you know, there's definitely a backlog. Everybody is adapting to technology, and the technology is still, you know, is still getting into place, in the sense that sometimes the video platforms don't work. So I have had my camera not working. I can see the judge can't see me. And so then I had to quickly call into the courtroom on the phone numbers and just do a telephonic, you know, hearing before the judge. So there's a lot of pressures on the lawyers in terms of time and using technology and adapting to it. It's the same for the judges. We're also in the middle of a pandemic. So, you know, there's this enormous pressure or an alternate reality that we're all living in, where people are dying around us. We could get sick at any time. Our clients could get sick, or our loved ones could get sick at any time. And so there's a tremendous pressure on all of us as human beings. And I think factoring that in is critical. It's also recognizing the enormous pressures that the judges have in, you know, not having the support and the resources they have because everyone is social distance and working online. So, you know, I will say that that is something that the courts face. And I think for what's important for the courts always is having everybody know their oral arguments and their facts and what their clients want, being prepared when they come to court, so that you're not taking up the court's time in having to come back at a later date because, you know, somebody doesn't have the authority to agree to something the judge says, or they haven't talked to the client to get permission from the client for something that might be proposed. So I think that helps the courts if the lawyers and the litigants are better prepared. You know, it's the same if it's a mediation. You know, the judges want to see it go to mediation quickly, to have an effective result, to have it documented. You know, there's an issue that the judge needs to address, to have, you know, the issue finely tailored and crafted in writing by the parties before the mediator, before it comes back to the judge. I have unfortunately seen, you know, statements in mediation that was so confusing, it generated a whole host of further litigation because nobody could quite understand what parties wrote, you know, at 5:45 before they wanted to close at the 6 p.m. mediation. And now everything that's in the statement is confusing, or people use a form. And the form is built for X matter, and this is matter Y in a completely different facts and legal arguments. And people try to squish in the reasoning or the stipulations or the terms of the settlement, and it makes no sense. It just doesn't apply. And you have to go back to court to litigate the whole thing. So I disfavor the use of forms. And if you're using a form that has 2 sentences or 3 lines to write something down, to me, you're dead in the water right there. Because there's no way to go on a form that has 3 lines left, or that has 3 lines for somebody to input language, which almost is impossible when you're trying to settle a case. So I think having tremendous clarity, or really thinking through, if we're using a form, even a basic thing of how much space are we giving for parties to write, so that they're writing it clearly and not, you know, crossing arrows from there, drawing circles to like go back to that. And now nobody knows whether the defendant has agreed to this extended period of time, or whether it's all defendants or one defendant, because the language on the form was either in singular or in plural, and there were multiple parties, and now we're not quite sure which of the parties agreed, which of the defendants agreed to this particular thing. So I think having those kind of clarity, minute, critical, minutia, anal clarity on what the settlement is between which parties, what, when, how, and why, to the best of one's ability, and write that down is critical. Of course, there will always be mistakes. Of course, we're human. Of course, there will be things that we didn't consider. But within our human ability to make sure that the details are there minimizes future litigation. So I'll say that. And just to come back to, you know, it took me 5 or 6 years of being part of the litigation, the executive committee of the litigation section before I was chair. It was the most profound experience of my life, and being chair was one of the most profound leadership experiences for me. There's not a lot of women, there's very few women that have chaired the litigation section of the Los Angeles County Bar Association, and the LA County Bar is, I think, the third largest metropolitan bar in the country. The litigation section is amongst the largest sections. And I saw my role as chair and our job in the litigation section is really working closely with the court systems to help and support the courts, both the state and superior courts, in their role and in helping the courts, the bench and bar, communicate better with each other and to focus and to, you know, to bring about greater collaboration between bench and bar, because neither one works in isolation. The judges need us and our support as lawyers in the legal community, and we need an effective judiciary and the support of the judges in the work we do. And so we have to work collaboratively with each other, because that's how we bring about the best results for our clients. And as chair, I was able to do that in the sense of being able to support the courts if they had a need, you know, bringing it to the attention to our members, providing information from the bench to the bar and vice versa, and just bringing about greater dialogue and discussion so that, you know, we could get everything within our legal system as litigators working more effectively and functioning better. You know, also being a minority attorney or a more diverse attorney, I try to bring about greater diversity in our executive committee to have more women represented. We already did have a lot of women, and I will give credit to all the prior chairs of the Bar Association that were ahead of me, who did a phenomenal job on that. I only had to build on that and expand it further. And so I'm happy with that. And I think also when the, you know, when the riots, I'm sorry, not the riots, oh my God, why did I even say that? When the protests happened and all the incredible pain and sadness over, you know, finally having voices of color and minority voices being heard after decades and decades of not being heard. It was kind of enlightening and really fulfilling for me to be able to work with all of the members at the litigation section executive committee to, you know, to draft a statement in support of more diversity within the profession, asking for lawyers and law firms to promote more diversity within the profession, either in terms of hiring or leadership position within firms and the legal community, and to really condemn kind of the bias that exists, you know, whether subtle, conscious or unconscious biases in the profession, discrimination in the profession, and just in society at large, and to really take a stand, you know, against violence against the, you know, the Black community. So I think that was kind of really heartening, and, you know, it's bringing our profession in line with what's happening. So, you know, that was great. And we were dark for April, but, and then by middle of May, we decided, hey, everybody's on Zoom. And so we started doing webinars on Zoom, and we had 150, 200 attorneys sign up for women in the law panel. We did rainmaking for diverse attorneys. We had that, our statement, you know, in support of, you know, in support of the Black community, condemning violence against the Black community, you know, looking for more justice and better serving justice within our communities, including for people of color and minority communities. We have that statement up on the LA County Bar website. And so I think those were really, to me, that was really heartening. And to see that our profession is moving with the times and kind of supporting all our constituents, that was really heartening for me.
Monisha, on this series of webinars, we often talk about issues of cross-cultural negotiation, and you've mentioned that you represent a lot of clients from India and that you yourself had practiced in India for many years before you came to the United States. And I've got my little trunk-up elephant that I got in Mumbai that you can see over my shoulder there.
I did. That's the first thing I noticed.
Yes, I got him right off of Colaba Causeway there, and I'm sure I paid a fair price for it too in Mumbai. Why don't you talk to us a little bit? We have a few minutes left about cross-cultural issues, norms of negotiation in India that might be different in the United States, and things that mediators in the United States might need to know about those kinds of situations.
Yeah, so, I do a lot of work within the Indian community. I have a lot of clients who are of Indian origin and founders of various companies. So what I will do also is, in an existing case, even if, they have counsel, sometimes lawyers will reach out to me to say, can you help us on the specific understanding of how this cross-border issue, legal issue can be addressed, or this cross-cultural issue can be addressed. And to me personally, and these are again my personal views, that some of the things that matter, and these are some of the ways that I get my clients to do something, is family is a big thing that matters for people of the Indian community. So preserving family and preserving those relationships can be one of the most important things for a client of Indian origin. So whether there's a business dispute or it's a divorce or whatever else, somehow preserving the immediate and extended family relationships is important. And this is what I have seen for my clients. And so that is something I factor in for them. And it impacts how much money one is willing to give or forego to preserve family relationships. A lot of times, image and prestige within the community is important. The way one is perceived within the community is important. And people, again, are willing to give up other monetary pieces in exchange for preserving image and prestige within the community. Legacy is also important for clients. The next generation, preserving their businesses for the next generation is also important. And so, the Indian community also it's an immigrant community. They traditionally, and I will say this, when I was growing up in my family, there were just three disciplines. It was religion, education, and family. Those were the three most important things in my household growing up, and everything else came after that, and there was usually never any time for anything else once you got done with religion, family, and education. And so those kinds of things matter within certain ethnic communities. The relationships matter more than the dollars and cents on the table. And crafting a result that includes those or factors that in sometimes can be the way to resolving something or helping a client feel value is given or received because one kept the relationships alive and preserved something for the next generation, held family together, maintained one's image and reputation and dignity within the community.
Okay, very important to know. We have just a couple minutes left. People who are listening may have questions. We have an audience of manageable size today. I don't think I have to call on people. So if you have a question, please just unmute yourself and ask.
Can I go for that?
Mr. Singh,
first?
Please.
Hi, Monisha.
Hi, Vikram.
Hi, Natalie and Jeff. Thank you for the webinar. Monisha, I would really want to know, how are clients in India looking at mediation? Are they considering it, or is there some change in that?
Yeah, so, you have to remember that the dollar is trading at 70 or 75 rupees to the dollar right now. So the price point for litigation for a company based in India is much, much higher than it is for a company based in the US. So yes, parties are always interested in mediation and resolving a dispute. You know, litigating in another country is never easy. And so even when I have worked with clients who go into India, I always help them craft a response that does not involve litigation, because you never want to litigate halfway across the world, whether it's in India or the US, because it's a different system, it's a different time zone, and it's time consuming, and it's problematic. I shouldn't say problem, it's challenging. Trying to do anything halfway across the world is challenging and can be more emotionally draining. So yes, clients are interested in mediation and resolution. One of the biggest things that I think I have to do with clients is helping them understand the differences in the legal system and the way business is done both sides, and why a particular settlement offer has value. Right, so sometimes in a contract, the representations and warranties are critical for a U.S. company, and a company in India goes, "Yeah, what is that, and why is it of any value?" And helping people understand that in the U.S. this is a value, and helping people in the U.S. understand in India this is really what they care about. Right, the other stuff doesn't matter, because it takes 10 years, or it'll take many years to litigate a matter. So if you breach a rep or warranty, in India, there's not much, there's limited options for people to resolve it. So yes, so definitely mediation and settlement are an option always. A, because of the price point, and B, because it's just people want to have it resolved and not have an international litigation hanging over them. But I think helping people understand what they're getting and how it translates into the business and legal sense on either side of the pond in two different countries on two different continents is critical to having an effective resolution.
Okay, we have time for one more question, please, if somebody would care to pop in. Janice, please.
Hi, thank you for your insights today. Really appreciate them. I wanted to ask about rainmaking, not being able to be in person, bringing into business, bringing in the rain. How has the pandemic affected that? And how do you continue to develop resources?
Thank you, Janice, and thank you for your comment. Yes, I totally agree that going into a mediation, you have to write down what you want and have language ready ahead of time. And it's not just with a mediator, it's even in court. Because sometimes the judge will do the mediation and say, come back and read it into the record. And if, I have prepared well ahead and written out everything well ahead that I knew I wanted if things went, way A or way B or way C, so that when I went 15 minutes after signing an agreement and I had to read it into the record, I knew that the talking points I wanted were read effectively into the record and were there. So whoever prepares better has a better outcome. So thank you for that. Someone I work with, a marketing person I work with, says it went from E nothing to E everything. So everything is online from being nothing, So I think in some ways what's helpful and is less time consuming or more time consuming, depending on how you look, is doing thought leadership and putting our articles online, either on LinkedIn or on trade organizations or anywhere else. So I like writing articles. I like researching and writing and putting out, things. And I like putting out things that help people actually. I think being a lawyer is a privilege. I had the opportunity to go to law school and to be a lawyer, and I can read and understand a legal matter in a way that's different from a lay person can. And so I like writing things that are simple and easy. People are empowered to read and understand them. But it's time consuming, right? Because I have to research and understand it myself and then put it in a way that's easy for my clients or a potential client audience can read. So I have to contrast that with driving in Los Angeles to a business meeting or to a trade association meeting or a networking meeting, shaking hands with people, meeting in person. So I think it's moved from in-person gatherings to online marketing, online strategies, online visibility, putting out little pieces that are helpful to clients. So I think everybody's in that transition. And I think the better we are able to get out there online and have an online presence and a virtual presence that's meaningful to clients, I think, and that's helpful to clients, and is not just, self-promoting. I think people resonate with that. And, if you help people, I think they will, without any expectation of getting something back, when they have a need, they think, oh, that person put out something that was easy for me to read and I really got something out of it. Maybe they know something about what they wrote about. They might actually have a few brain cells, and let me talk to them.
Okay, that's a very upbeat and optimistic note, Monisha. Thank you. We once again want to mention the St. Joseph's Food Bank in Venice, California, and the URL for that has been posted. If you're in a position where you're able to contribute to St. Joseph's or another food bank in your own community, that would be wonderful. We love it when people do that, please. We've exceeded $50,000 now in contributions to food banks. That's a lot of people in need who we've been able to help through these webinars. And Natalie, thank you so much for organizing the whole
Jeff, I'm going to jump in as you
whole
take
Real
a
Work for
sip.
Food project. Yes, go ahead, Monisha.
I just want to congratulate you and Natalie. This is just an outstanding endeavor. And let me tell you, there are other people in the legal profession and the judiciary that I have kind of discussed this with, just mentioned to them, and everybody has been so congratulatory and complimentary of this effort. It's really, really incredible. So, this is an outstanding job you're doing, Jeff, in holding these webinars that are of value to the clients and also raising the money. So, kudos to you and to Natalie, really.
Well, thank you so much for your kind words, Monisha. We really owe it. Natalie was really the thought leader in putting all of this together and launching it. We've had wonderful speakers, yourself and many other speakers, and we have some other terrific speakers lined up in the weeks and months to come. And mostly to the people who tune in and watch these, both on the live webinar, and then we post recordings of these. And it's really the people who watch and are moved to contribute to the food banks. They are really the greatest key to the success of the whole thing. So God bless them all and thank them. So with that, Natalie, any final words?
Jeff, only to say to Monisha, thank you so much for sharing your time, your expertise, and your experience with us. It was very valuable, and we greatly appreciate the donation of your time with us.
Yes, Monisha, thank you, and thank you all. And with that, our recording is complete.
Thank you.
Thank you.